Good morning, and thank you for joining us today. My name is Grant Degginger. I'm the chair of Lane Powell's Government Law Practice Group, and I'm going to be moderating today's program. Please note that all of your phones and microphones are muted as you listen, but you can submit questions through the Q&A function at the top of your screen. We'll reserve time at the end of the presentation to address your questions. Now, as many of you know, on April 12th, 2017, the final rules for the Seattle Secure Scheduling Ordinance were posted with an effective date of July 1, 2017. In this webinar, we are going to provide a high-level overview of the rules and their implications for your business and answer as many questions as we can so you can prepare to comply when the rules go into effect just a few weeks from now. On behalf of Lane Powell and our co-sponsor for this event, the Washington Retail Association, we do appreciate your participation in the program as an opportunity to help companies in Seattle comply with this new ordinance. Today's webinar will be presented by two of my colleagues, two Lane Powell shareholders, Catherine Bradley and Krista Hardwick. Catherine is a leading member of our employment practice group and chair of Lane Powell's Wage and Hour group. For over 30 years, Catherine has devoted her practice to representing and advising employers in organizations of all sizes. She helps employers avoid all kinds of employment claims by preparing effective workplace policies and counsels them through challenging situations, including reductions in force, separations, and terminations. Krista has served as an in-house counsel for Providence Health System as an experienced employment defense attorney in all facets of employment law and traditional labor law. Whether negotiating a union contract or handling a union grievance or assuring compliance with a myriad of employment and wage and hour laws, Krista provides strategic counsel on policy implementation and policy and law interpretation, operational strategy, pay practices, layoffs, terminations, and discipline, as well as compliance with emerging federal, state, and local laws and ordinance like we're dealing with today. So with that, we'll get started. And Catherine, I think you're going to start us off.
Thank you, Grant. One of the reasons that we decided to do today's webinar for you is that we've been fielding many questions from our clients about this ordinance since it was first adopted last year. And over the last 6 months, we've spent quite a bit of time answering questions, trying to figure out how to resolve some of the gray areas. And we've also submitted comments to the City of Seattle on the rules, and we're successful in getting several of those rules modified. What Krista and I are going to do today is provide a general overview of the ordinance and the rules. And to the extent there are those gray areas, we'd encourage you to contact us following this seminar with your more specific questions, because this is one of those ordinances that will likely impact different businesses differently depending on your industries. So we're glad to help you walk through some of those nuances. Starting first with the city's intent in adopting this ordinance, we think it's important to keep those intents in the background as we walk through some of these rules today. So in the ordinance itself, the City of Seattle stated that its legislative intent was to promote predictable schedules that work. And they state specifically that these new secure scheduling practices are intended to promote race and social justice, employee health, safety, and welfare, provide greater economic security to employees, provide increased employee input into scheduling, and reduce involuntary part-time work. So to the extent there are those gray areas, you do need to keep the legislative intent in mind. So when does this ordinance become effective? In just over 3 weeks, as Grant mentioned. July 1st is the effective date of the ordinance.
So even though the ordinance becomes effective in only 3 weeks, the question is, will there be a grace period to comply? The city has provided kind of similar grace periods on some other ordinances, and it's not technically called a grace period, but there will be a soft launch for this ordinance. And what that means is that for the next 6 months until December 31st, the city won't be issuing any penalties or fines for violations of the ordinance, except for egregious violations such as retaliating against an employee who exercises rights under the ordinance or something like that. So employers will have until the end of the year to work within their internal policies and procedures and work with the city to get into compliance and not have to worry about penalties.
Thank you, Krista. And for those of you who are listening along, we wanted to give you a link to where you can find more information from the city. And we have to commend the city in this regard because there's quite a bit of information that's posted at this link. And we do encourage you to go there and study the city's summaries, rules, the ordinance itself, and some of their templates and posters as well.
So the kind of first question that everybody needs to look at is which employers are even covered by this ordinance, because it only applies to a really specific subset of businesses who do business in Seattle. And so to determine whether or not you're covered, you need to determine whether or not you're a retail establishment or a food establishment, and you need to have 500 or more employees worldwide. And obviously you need to have 1 or more employees who are actually working in the city of Seattle. Now, the phrases retail establishment and food establishment are defined in the law or the ordinance. And to determine whether you are one of those things, you need to look at something called your NAICS code. Now, every business doing business in Seattle has an NAICS code, and you would have been required to actually list that code on your application for a business license with the city of Seattle. So you want to look back, if you've got that still on file, look back at that application and see what your NAICS code is. If it starts with the number 722, you are a covered food service establishment, and it's going to be longer. It'll probably be 6 digits, but if the first 3 numbers are 722, you're covered. Now for retailers, your NAICS code is a range, and if it starts with 441 and it goes anywhere up through 453998 and falls anywhere in that range, you're a covered retail establishment. Now, if you've somehow misplaced your application for a business license or you don't keep it on file, you can go to the city's website. It's www.seattle.gov/licenses, and you want to click the link for Find a Business, and then you can look up your business at that site and it will give you your NAICS code.
All right, so assuming you're a covered employer, the next question you need to answer is which of your employees are covered? Now, keep in mind, only non-exempt employees are subject to this ordinance, and those employees need to be working at a fixed point of sale location, which includes areas open and closed to the public, and those non-exempt employees need to be spending at least 50% of their time working at that fixed point of sale location within Seattle's city limits. The city was good enough to give us one exclusion, and that is those who are hourly, administrative, or professional employees. Now, we think that's a pretty broad category. We're not sure exactly which employees would be covered within that classification, but the city did inform us that there are at least 3 positions that they've identified that fall in that category. And those are the ones we identify here on our slides. So the human resources, payroll, and receptionists. And those are specifically called out in the rules.
Okay, so assuming you are a covered employer and you have covered employees, there are a myriad of requirements that you're going to need to comply with in the coming few months. And the first one is, what do you do when you hire a new employee? You need to provide what's called a written good faith estimate of the work schedule to the employee upon hire. And that is a form that you can actually find also on the City of Seattle's website that we mentioned before. And what needs to be included in that written estimate is the median number of hours the employee will be scheduled to work each week, whether the employee will need to work on-call shifts, And you need to provide that information for a 1-year period of time from the date of hire, and you can break it down into 3-month increments. So most employers will say, here's your median number of hours for quarter 1, here's your median number of hours for quarter 2, et cetera, et cetera. And again, you can access that form on the website for the City of Seattle. In providing that good faith estimate and determining the median number of hours, just keep in mind that median is not the same as an average. Those are two different things. So a median is the middle number in a series of numbers. And an example is provided on the slide. If you've got a series of numbers that are 1, 3, 4, 10, and 20, the middle number in that series is 4, so 4 is the median. And this is a little bit complex, and so feel free to contact us after the presentation if you need help calculating what that median number of hours is in any particular situation. We've walked a lot of clients through that.
All right, so the next issue you need to address is what are your obligations if you need to deviate from that hiring estimate that you just provided? Well, what this ordinance requires covered employers to do is engage in an interactive process. And those of you in the HR field undoubtedly recognize that term as one that was adopted from the Americans with Disabilities Act. But the requirements of this ordinance are quite different than what an employer might do to provide a reasonable accommodation. This ordinance is quite complex, and we do commend reading the rules if you're going to be responsible for administering this, because there are a number of very specific requirements and record-keeping requirements. So for the interactive process, what the rule requires is that an employee must notify an employer of significant changes, and likewise, the employer must notify the employee and then engage in that interactive process when they recognize that there is a change that is needed. And so that process must be initiated under the rules within 1 week of receiving notice. And it contemplates that there is a problem-solving discussion with the employee about that change. The rules also state that the process needs to be completed within 3 weeks. And a revised good faith estimate needs to be provided if a change occurs. There is a recognition that the process may need to be extended beyond 3 weeks, but you can only do that as an employer if the employee agrees mutually with you to extend the deadline. And by the way, the rules require that that extension be put in writing. So more specifically, the rules state that during that interactive process, the employer needs to explain the significant change. And if the employer's reason for that significant change is a bona fide business reason, the employer needs to explain the bona fide business reason. The employee needs to have an opportunity to respond with their concerns about the change. And the employer needs to be prepared to address the potential next steps to address the employee's concerns. And then at the end of that process, there is a revised good faith estimate. While the rules recognize that this interactive process can take place in person, by phone, by email, or text, we suggest to you as a covered employer that you really should be documenting this interactive process so that you can comply with the city's record-keeping requirements.
So Catherine just went through the interactive process that an employer needs to go through if the employer wants to deviate from that written good faith estimate that they provide the employee. If the employee wants to deviate from that and request a change to the employee's work schedule, there's also a process that needs to occur. And this is different than when an employee requests a schedule change after the schedule has been posted, and I wanted to call that out. Right now, Catherine and I are just talking about changes to the schedule before it is posted. So if an employee wants to request a change to their work schedule, again, before it's posted, they do have the right to do that, either at the time they're hired, if you provide them that good faith estimate and they don't like it, or anytime kind of ongoing during employment, if they want to change their work schedule. They can suggest different shifts, different hours, different work locations that they may want to work at. And again, if that happens and you receive a request from an employee, you must engage in the interactive process to determine their preferred schedule and location. And just like the interactive process that Catherine just talked about, this is very similar. It's a problem-solving discussion with the employee where you talk about their request. If the employee is requesting the change due to something called a major life event, which we'll talk about later, you're going to want to talk about what that is. And you can request verifying information from them if there is a major life event. And we'll also talk about what type of information you can request a little bit later in the presentation. And then you're going to want to discuss what changes you can make that to accommodate the employee's concerns and the employer's needs. And in the event you're going to have to deny the employee's request to change their schedule, you're going to want to talk about potential next steps you can take that to accommodate it in the future.
All right, so what are an employee's rights to request a schedule change before the written work schedule is posted? The rule is quite clear in this regard. So if the reason that the employee is requesting the schedule change is because of the employee's major life event, here a covered employer is legally obligated to grant that request unless it has a bona fide reason to deny it. And we'll talk about what those terms mean in a minute. On the flip side, if the employee's request is not due to a major life event, the employer may grant or deny for any reason that is not unlawful. So important to understand what those terms mean.
Thank you, Catherine. So the first term is a major life event. This comes up frequently throughout the rules. And essentially, a major life event is any significant or substantial or important event that's going to impact the employee's ability to get to work, essentially. And there's several examples listed on this slide, and they include issues with transportation or housing. So, for example, a flat tire may qualify as a major life event. The employee's own serious health condition, caregiver responsibilities. So that would be an employee has, for example, a child with a serious health condition that they need to stay home and care for. Enrollment in a career-related educational or training program, or the employee's other job or jobs. So if you have an employee who has another job, that being scheduled to work at that job at the same time they're scheduled to work at your job can qualify as a major life event that could require you to grant their request for time off to go work at their other job. Now, just to be clear, other job or jobs does not include independent contractor situations. So if you have an employee who has a side gig as a lawnmower or a babysitter or something where they're an independent contractor, that would not be a major life event. And if they need time off to do those types of activities, you would not be required to grant that request.
So as Krista mentioned, the rules do address that the employer has the right to request verification from an employee who's requested a schedule change because of a major life event. And the rules address what verification the employer may ask for. It can be the employee's own written statement. It could also be documentation from a third party, like a landlord providing notice of eviction. It could be a pay stub from another job. It could be a notice from the school or a class syllabus. It could also be healthcare provider documentation for the employee's own serious health condition. Now, the rules do state that the employer's request for verification must be reasonable. It shouldn't cause the employee to incur expense, and it shouldn't be designed to deter employees from requesting schedule changes. But do note that the employee can, in most instances, provide their own written statement as verification. So an employer needs to be sensitive to the fact that the employee's own written statement may be sufficient.
If an employee does request a change to their schedule, again, in advance of when it is actually posted, and they identify a major life event as being the reason for the schedule request, The employer can only deny that request in a very limited set of circumstances. Typically, those requests are going to have to be granted. However, if the employer has something called a bona fide business reason, then the employer may deny the request based on a major life event. And Catherine's going to explain what that means.
All right, so what is an employer's bona fide business reason? And we have 2 slides that outline the rules in that regard. So one of those is, I think, probably the most obvious. If granting that request would cause the employer to violate a law, an administrative rule, a collective bargaining agreement, or an executive order, that would be a legitimate or bona fide business reason for denying the employee's request. Another one would be where the employer can identify significant and identifiable burdens of additional costs. Now, note the language in this rule, it's a pretty high burden for an employer. And there's more definition in the rule of what that means. Another instance that would qualify as a bona fide business reason is where the employer would need to take action that would require them to pay premium pay or a higher wage. So this is one where we've received quite a few questions from our clients. A lot of employers mistakenly believe that they would be required to grant scheduling changes that would put an employee into overtime, and that is simply not the case under the rules. So you can deny a request from an employee that would require payment of overtime or a higher wage under the Seattle Municipal Code, the Fair Labor Standards Act, the Washington Minimum Wage Act, or the employer's own written policy. And the rules specifically call out that if you have a policy that requires holiday pay and the employee's request would put them into holiday pay, that would be a bona fide business reason for denying that request.
This is actually another question that we've fielded from several of our clients in the retail and food service industries, and it comes up a lot. And that is, what if the employee makes a schedule change request that would require the employer to reorganize work? So for example, if you have an employee, if you have an employee who works the day shift normally, and then you have another employee who works the graveyard shift, and the employee who works the graveyard shift comes to you and says, I have this major, they're not going to use these words, but they have this major life event that really requires them to switch to day shift. Maybe they need to stay home at night and care for a sick child or something like that. Do you need to grant that schedule change request if it's going to require you to displace your employee who's already working the day shift and switch them to night shift? And the answer is no. A bona fide business reason, excuse me, I'm sorry, we switched slides on you guys, so we're going to go a little out of order here. We're going to do this slide, finish this slide, and then we'll go back to the previous slide. So if it's going to require you to reorganize work and displace another employee, that is a bona fide business reason to deny the schedule change request. So now we're going to go backwards a slide.
Yeah, and so Krista called out the first factor here on this slide, which is the significant inability to reorganize work. But the rule does have a couple other instances that would qualify as a bona fide business reason, such as a significant detrimental effect on business performance, significant inability to meet customer needs or demands, significant insufficiency of work during the employee's proposed work period. So again, just note that these are pretty high burdens for the employer to meet in order to deny that request if it's a major life event. So the next thing we want to talk about is when an employer must address clopenings. So clopenings are shifts that are less than 10 hours apart. And the ordinance and the rules have a little bit further definition on this one. And what they state is that this addresses a situation where there's less than 10 hours after the end of the previous calendar day's work, or there's less than 10 hours following the end of the work shift that span 2 calendar days. So we've given you the citations to the ordinance and the rules there. You will note that there is no reference in either of the ordinance or the rules to clopenings, but this is the terminology that most of us are using to describe this scenario. So if a clopening occurs, the employer cannot require the employee to work that clopening unless the employee requests or consents to that shift. So the employee has the right to say no. If the employee does consent or request, the employer must pay time and a half of the regular rate of pay for any hours worked that are less than 10 hours from that earlier shift. And employees do have the right to revoke their consent at any time. So this is one of those areas where we recommend as a best practice that an employer establish a process for the employee to revoke consent so that there is advance notice to the employer when this situation may occur.
Okay, so many of the covered employers who we work with also do what's called split shifts, and that's pretty common in the retail and food industries. Split shifts are not the same as clopenings. We just want to be clear to distinguish those. A split shift does not require that premium pay for the second part of the shift or for any part of the shift. And a split shift is where an employee, they're just working one shift rather than two, but the shift hours are not consecutive, and they're interrupted by an unpaid employer-required period that is between 1 and 4 hours in length. And it's not a meal period or a rest period. It's the situation where you have an employee who comes in, for example, opens the store in the morning for a couple of hours, and then you have them go home for 3 hours, and then they come back when you get a little busier in the afternoon and finish their shift. That's a split shift, and you don't have to pay premium pay for that.
So in that regard, this is one of those areas where we would recommend looking at the rules so that you understand the difference between a clopening or a split shift. So again, do take advantage of the opportunity to read those rules in advance of the effective date. Turning to a new subject, what must employers do to provide current employees advance notice of the schedule under this ordinance? So here is a new requirement for employers in the city of Seattle who must provide all current or existing employees with a written work schedule at least 14 days before the first day of that work schedule. And what the ordinance says is that if an employer doesn't provide that 14-day advance notice to the employee has the right to refuse to work hours that are not included in that written work schedule. So new employees are entitled under the ordinance to a written schedule upon hire that runs through the last day of the currently posted schedule. So if you hire an employee halfway through your 14-day period, you can simply place them on the schedule, and you don't have to provide 14 days advance notice at that time. You just put them on the schedule. And that same rule would apply to employees who are returning from leave, are transferred to a different position, are promoted, reassigned, or if they request a work schedule change, you just put them on the schedule. But following that schedule, they would be included on the regular written work schedule on the 14-day notice schedule.
So you post your written work schedule, and the first day on the schedule, like Catherine just said, is they get at least 14 days advance notice. So after you post the schedule, how can you change it after it's posted, and can you change it? And there are some very specific rules around that. As Catherine mentioned, if you do change your written work schedule after it's posted, the employee can decline to work any hours that are changed from the original schedule. So there's no guarantees that you're going to be able to change it. But if you do want to try, you must provide timely notice to the employees of the change. And that can be provided in any number of ways just to ensure that the employee receives the notice. So you can go talk to them in person about it. You can shoot them an email. You can call them on the phone. You can send them a text message or any other format that you use to communicate with your employees about schedule changes. Now, again, the procedure I just went through is if the employer wants to change the schedule after it's posted. If the employee wants to change their schedule after it's posted, there are some different rules for that. If the change is foreseeable, So for example, if the employee has a doctor's appointment that they need to go to next Monday and they're scheduled to work next Monday, that would be a foreseeable change. And what they need to do is provide notice of the request to the employer, and they need to follow whatever your normal and customary notice procedures are. For unforeseeable changes, they must just provide notice as soon as is practicable. And in many cases, that's going to be either very shortly before their shift starts or right at the beginning of their shift. That's the situation typically where you've got an employee who wakes up and they're scheduled to work that morning, but they're really sick, so they need to call in sick. And in those cases, they must, if you have call-in procedures for that situation, they must comply with those. Another issue here where you've got employees calling in sick or wanting to change the posted schedule is whether you can require them to find replacement coverage. And we're going to talk about that in a little more detail later. But just for purposes of this slide, you cannot require employees to find a replacement to cover their shift if the absence is due to a major life event or an emergency.
All right, so when can an employer grant or deny a schedule request after the schedule is posted? Well, first of all, if the request is relating to an emergency or a major life event that's covered by another law, and the examples given here are the FMLA or the Paid Sick and Safe Time law, the employer is required to grant that request to the extent required by those laws. On the other hand, if the request is due to an emergency or a major life event that isn't covered by another law, the employer has the ability to grant or deny. And the example there is a flat tire. There is no other law that would address a flat tire situation.
So after the written work schedule is posted, and the employer or the employee, and the employer needs to make a change to that written work schedule, there's something called predictability pay that typically is going to need to be paid to the employee. And this is over and above their usual scheduled wage that they're going to earn for actually working the hours. So if an employer adds hours to this written work schedule, or even if you don't add any hours, but you change the dates of the shifts or the lengths of the shifts, then you are going to need to pay the employee 1 hour of pay at their scheduled rate of pay, again, in addition to their normal wages. Now, if you add less than 1 hour to this schedule, so it's only like 20 minutes, you can prorate that. You don't have to pay the full hour of pay. You just need to pay an additional 20 minutes of pay in addition to their wages. And then there is also a 15-minute grace period. And this is just the city acknowledging that in the retail and food industries, there's frequently situations where you're going to need to ask an employee to stay 5 minutes late or come in 5 minutes early just to cover shifts. And in those situations, you don't have to pay any predictability pay as long as it's 15 minutes or less. Now that's adding hours or changing the dates of shifts. If you're going to cancel a shift or subtract hours from the written work schedule or schedule an employee for an on-call shift where they don't actually need to report to work, predictability pay is also due, but it's calculated a little bit differently. And so what you need to do in these situations where you're basically taking away hours is you need to pay the employee half the scheduled rate of pay for all the hours you took away. So if an employee is scheduled to work 9 to 5 on Monday and you change that after the schedule is posted and have them only working 9 to 12, so you took away 5 hours, you're going to need to pay them half of 5 hours pay, so 2.5 hours pay, in addition to the wages they're going to earn for their shift. And for on-call shifts, if they're not called into work but they have to be on call, you have to pay them half their scheduled rate of pay for the entire on-call shift.
We want to take a pause here to make sure you understand that the scheduled rate of pay as used in the previous slide in determining predictability pay is not the same as the regular rate of pay, which employers are very familiar with. So keep in mind the scheduled rate of pay under the ordinance is the rate at the beginning of the employee's work shift. So if that rate should change during the shift, say the employee goes into overtime, that doesn't really matter. You are paying the rate of pay at the beginning of the work shift. And a similar rule for on-call, the scheduled rate of pay for paying for that on-call period is the rate at the beginning of the work shift on site, not the pay for the waiting period.
Okay, so there are some exceptions to the requirement to pay predictability pay for changing the work schedule after it's posted. And there's, we've got 2 slides on this, I think. So there's actually quite a few exceptions, and I'll just go through them real quick. And then we're gonna elaborate on most of these later in the presentation. So if an employee volunteers to work additional hours in response to something called a mass communication, you don't have to pay predictability pay. If an employee consents to work additional hours in response to something called an in-person group communication, you also don't have to pay predictability pay, and we'll go through what those are later. If the employee is the one requesting the change to their schedule after it's posted, if that is documented in writing, and again, the employee initiated the schedule change request, you don't have to pay predictability pay. And then operations failures are another exception. Mutually agreed upon work shift swaps among employees are an exception. Additional hours that an employee consents to work after accepting an employer's offer of additional hours prior to hiring externally is another, that's kind of a big exception, and we're going to go through that in detail later. And then finally, hours that you subtract from the posted work schedule due to disciplinary reasons. For example, you have an employee who steals and you take them off the schedule because of it. That is not going to require any predictability pay as long as the incident is documented.
All right, right. So Krista mentioned that each one of these terms in the ordinance is further defined. So we're going to go through what each of those terms means, and starting first with what is a mass communication. So this is defined as a written message that's distributed to 2 or more employees about the availability of hours. And the ordinance and the rules specifically requires that that mass communication contain specific language. So it needs to state that it's a mass communication. It needs to state that the acceptance of the offer is voluntary and that the employee has the right to decline it. And it needs to state that accepting the hours does not require the employer to pay for compensation for that work schedule change. Now, mass communications can be limited to those employees who are qualified to perform the work, and you can limit it to those employees who would not incur premium pay, such as overtime. The rule also states that translations are encouraged for mass communications, but they are not required.
Another exception to predictability pay, like I mentioned earlier, is an in-person group communication where an employee volunteers to work additional hours. And in order to have a valid in-person group communication, what you need to do is inform at least 2 or more employees who are currently working about the availability of hours due to present and unanticipated business needs. That can just be as simple as a conversation. You can just walk up to the employees who are currently on shift and let them know, you know, Annie called in sick. She's not going to be able to work tonight. I'm offering these hours to you guys. You also have to state that it's voluntary to accept and they have the right to decline the additional hours. And you have to inform them that they will not be paid that premium pay for working the additional hours. The in-person group communication also has to be directed to employees who are not already scheduled to work those additional hours, and they need to be qualified to perform the work.
The rules also define what is meant by an operations failure, which would be one of the exceptions as well to predictability pay. And so the rule here is pretty specific. If there's a threat to employees or property, a public official recommends that you shut down operations. There's a power outage, public utilities failure, a natural disaster, and then there's a catch-all, any other cause that's not within the employer's control, and some exceptions that are suggested. Weather events or events that would cause an employer to violate a law would be considered operations failures.
Okay, so those are all exceptions to the requirement to pay that premium pay for schedule changes. We're going to move on to kind of a new topic now, and it's replacement coverage. This is a big topic for our clients, and I've fielded probably 10 different questions on this issue alone over the past couple months, because it seems like it's common in the industry to require employees to find their own replacement when they aren't able to come into work. And this rule is going to change that a little bit. So there are 3 kind of different scenarios here. So we'll just go through them one by one. The first scenario is you cannot require an employee to find a replacement, and you cannot even ask them to try if they're requesting a schedule change for a reason protected by law. So if an employee is taking FMLA leave, if they're taking sick leave under the Paid Sick and Safe Leave Ordinance, if they're taking, jury duty leave, if they're taking voting leave, whatever. Well, actually, there's no voting leave in Washington anymore, but any reason that's actually protected by another law, you cannot ask them to find replacement coverage. The onus is on the employer to find that replacement worker. Now, a little bit more lenient is the situation where the employee is requesting a schedule change due to a major life event, but it's not protected by law. So that would be like the flat tire situation or the having to work another job situation. In those situations, you still can't require them to find replacement coverage, but you can at least ask them to try. If they're unable to do it, that's fine, but you can ask. And then the last situation is the only situation where you can actually ask them to find a replacement worker, and you can require them to do that. And that's if they're requesting a schedule change for any reason that's not a major life event or protected by law.
All right, I'm turning then to the employer's obligations before hiring new employees or temporary staff. Again, these are new requirements under this ordinance. So what the ordinance and the rules require is that the employer first offer additional hours to current employees before they hire new employees or temps. And the ordinance prohibits an employer from actually hiring an external applicant, a subcontractor, or using a staffing agency in these circumstances without first going through the process for posting hours. So the employer has to post the notice of additional hours for 3 consecutive calendar days before hiring new employees. And then the employees actually have 2 additional days to consider that offer. An employer can post externally before those 5 days expire, but they can't hire until that 5-day process is completed.
So what must be included in the notice of additional hours? There are 3 things that you have to make sure you get in there. The first is the description of the position and the job title. And then the second is the qualifications for the job. And then the last is specific or general information about the total hours of work being offered, what the work schedule is going to look like, whether the shifts will occur at the same time each week, and how long you anticipate needing coverage. So is this a permanent position? Is this something where you're just needing additional coverage for the summer or the holidays? That needs to be put in the notice. And if you don't have all of that detailed information for that last bullet point, you can just say hours and schedule dependent upon the employee's availability. And that sentence has been specifically approved by the city.
All right, so who must receive this notice of additional hours from the covered employer? Well, the rules are quite clear here that it needs to be every employee on the employer's payroll. So you cannot limit that notice to full-time employees. Instead, it must be full-time, part-time, temporary, and seasonal employees. The exception would be employees who are on leave, have a planned vacation, or plan to use paid sick and safe time for that entire 3-day period of notice. It also recognizes that it's only employees on your payroll that you provide this notice to. So if the employees are actually jointly employed by a staffing agency and they're on the staffing agency's payroll, you would not need to give notice.
So as with most of the requirements in this ordinance, there are also exceptions to this rule. And you can proceed to immediately hire externally new employees if you receive written confirmation from each and every one of your employees that they're not interested in accepting additional hours of work, or if the notice of additional, or the notice of additional hours requirements do not apply to hiring programs that are pre-approved by the city's Office of Labor Standards. And that would include diversity programs, young adult hiring programs, supported employment programs for disabled workers. If you use those types of programs, you don't have to do this notice of additional hours, but the requirements are that you can't hire more than 15% of your employees through these programs. And again, they have to be pre-approved by the city of Seattle. Another exception is if you maintain something called a written access to hours list, and you get written declination of the hours from all the employees on the list. So what these lists are is a list you create. You put all of your employees who are on your payroll on this list, and then your employees can opt out of the list if they don't want to be receiving these additional hours notices. You can also have multiple access to hours lists, one list for each position or different lists for different locations or hours or shifts. But again, even if you maintain multiple different lists, you have to put all of your employees on each list and then let the employees opt out of which list they don't want to be on.
Alrighty, so we're going to talk quickly now about some of the posting and record keeping requirements. First of all, the employer has an obligation to post the OLS poster of this ordinance in a conspicuous and accessible place at a work site that's located in Seattle. The poster needs to be displayed in English and in the primary language of employees at that work site, and the employer needs to make a good faith effort to determine the primary language. And in addition to posting it, the employer must also provide individual notice to each employee at the time of hire. Either a copy of the OLS poster in physical or electronic form, or something that provides similar notice. And it could be done in a handbook, provided that it's given to every employee at the time of hire.
All right, thanks, Catherine. So moving on, assuming you've gotten into compliance with all these requirements and you're doing all of these notices and documentation, what records do you actually have to keep under the ordinance? You have to keep essentially any written document that you create that shows that you're complying with this ordinance, and you have to keep it for at least 3 years. And so some examples of the types of documents that you're going to want to hold on to for that 3-year period are the written good faith estimates of the work schedules that you're providing to employees when they're hired, the granting or denying of employee schedule change requests, because again, you're going to want to do that in writing and hold on to that. Advance notice of work schedules. So again, you post them 14 days in advance and you need to just keep a copy of those work schedules. And the best practice would be to somewhere on the work schedules include the date that you posted it, so that you have proof that you posted it 14 days in advance. Compensation for work schedule changes. So documentation proving that you paid that premium pay that's required and that predictability pay that's required. And then again, if you do the mass communications to employees, that's something you're going to want to hold on to. Those are going to be in writing. Employee discipline that results in changes to the schedules. You're going to need to keep the documentation of the discipline so that you can prove the reason why you took them off the schedule. Notices of additional hours, which is what we just went through, and then the written confirmation from your employees in response to those access to hours notices, and access to hours lists. If you decide that you're going to start doing those, then you need to keep those lists for at least 3 years.
Okay, so by now you're likely saying to yourself, oh my, how in the world am I going to maintain all these lists? Well, the city's given you an incentive here, because what the rules provide is that if you don't have those proper records, there is going to be a rebuttable presumption that you violated the ordinance. And it's going to be for the period of time that you didn't maintain the records, and for each employee where those records were not maintained properly. So it's going to be very important that you maintain all of those records for that 3-year period.
Retaliation is always a big issue. It's one of our hot button issues that we see in a lot of different areas of employment law, and it's an issue on this ordinance. Employers cannot retaliate against employees for exercising rights under the ordinance. Well, I guess technically you can, but there's going to be penalties for doing so. If you take an adverse action against an employee So if you demote them, if you terminate their employment, if you reduce their wages, if you give them discipline, those types of adverse actions, if they occur within 90 days of the employee exercising rights under the ordinance, there is going to be a rebuttable presumption that you retaliated. The city is just going to assume that you retaliated unless you can prove otherwise.
So when can you discipline an employee in relation to a schedule change? Well, you better be really, really careful, because if you engage in retaliation, as Krista just said, you're going to be in trouble. So the city has identified some instances where they think you can legitimately discipline employees. And these are the examples they've given. If the employee is abusing the reasonable notification and job requirements for requesting schedule changes before the posting of the work schedule, you may discipline. You can also discipline an employee who fails to comply with or abuses the employer's reasonable notification and job requirements. So obviously, you're going to need to have written policies addressing the process for providing notice to the employer and for requesting schedule changes, because you're going to need to show that the employee actually violated your policies in order to legitimately discipline. And you really need to be careful out there, because you're looking at a potential retaliation claim if you discipline and you're not permitted to do so.
So is there any way to get out from under this ordinance and waive the requirements of the ordinance? Yes, there is, but it's very limited. And this is only applying to employers who have employees represented by labor unions who are covered by a collective bargaining agreement. In those situations, both parties can mutually agree to waive all of these requirements if the collective bargaining agreement, or you can do an addendum to it, expressly references the ordinance by its name, and you have to put the citation to the ordinance in your collective bargaining agreement, and you have to say that you waive the requirements of the ordinance, and then the employees need to ratify an alternative to the ordinance. So some other structure for secure scheduling that meets the public policy goals of the ordinance, and that needs to be put into your collective bargaining agreement. If you meet all those requirements, then the ordinance does not apply to you.
All right, so it's important to keep in mind that if an employer violates this ordinance, employees do have the right to bring a lawsuit directly against the employer, and there's no requirement that the employees first go to the city. The city does have authority to investigate these violations, but if the employee chooses not to go through that process, they can directly file suit in court.
And then last but not least, we'll talk about the money. What are the fines and penalties for violating the ordinance? So again, I do want to reiterate, there is the soft launch. So these are not going to be assessed until 2018. You don't need to worry about it unless it's retaliation or something else that's really egregious. But once we get into that time period where the penalties start to be assessed, you can face liability just like paid sick and safe time. So it's up to 3 times the amount owed to the employee. In addition to that, you can be hit for $5,000 in penalties and fines, unless it's retaliation, which could go up to $20,000. And then you can also be liable for costs, including attorney's fees and interest, if litigation is commenced and the employee prevails in that litigation. You can pay not only your attorney's fees, but their attorney's fees. So it can get pretty expensive.
So Catherine and Krista, thank you so much for all of this great information and walking us through some of the important rules related to the ordinance. This is the part of the program where we call it the interactive process and answering some questions that have been posed by the audience. And so I don't know that we'll have enough time to get to all of them, but we'll take a shot at getting through some of them right now. For the ones that we don't get to, on the screen we have Catherine and Krista's email addresses, and obviously the firm's phone number as well, and they'll be happy to answer any questions that you have. You can email me, but I'm going to send it right back to them. So let's start with, here's one that came in, and maybe you could take a shot at it, Catherine. It's an interesting one that relates to perhaps a split shift situation. What if an employee wants to work both a lunch shift and a dinner shift in a day? Would there wouldn't be a 10-hour break between shifts? Is that a problem? And is the issue, with closed to open shifts and not open to closed shifts, is that the same kind of problem that you're going to have there in that situation?
Yeah, Grant, that's a really good question. This is one of those areas where it's really important to understand what a clopening is and what a split shift is. So this scenario that's being described is actually outside the clopening arena, because the clopening occurs where the shift is from the prior day to the current day, and this is all within the same day. So the employer would be permitted to do this without the predictability pay.
Okay. Krista, here's another one that's come in, and maybe you can take a shot at it. What if an employee asked to stay later than scheduled? Should the employer document that request?
Absolutely, Grant, because the predictability pay that's due for changing the schedule does not apply if the employee requests the schedule change, but that only works if it's documented in writing. So yeah, if an employee asks to stay later than scheduled or even asks to come in earlier, as long as that's documented in writing, then you don't have to pay that premium predictability pay.
In a similar vein, Catherine, can the employer offer the option to employees to voluntarily leave earlier than they are scheduled without penalty? And if so, again, should this be how should this be communicated, and should the employer document this as well?
Okay, this might be close to a trick question, Grant, because it seems logical that if an employee voluntarily leaves earlier, why should the employer be penalized? But the rules specifically state that the only time the employer doesn't owe that predictability pay is where the employee actually initiated it. So if the employer says to the employees, would you like to leave earlier, and it wasn't the employee's idea, they would be required to pay predictability pay.
Staying in that vein, Krista, here's another question that came in, which is, what if the employee stays longer than scheduled without approval? Do they still need to, to be paid extra?
So that's kind of one of those gray areas that we'd want to take a look at, with you probably individually. But, like Catherine mentioned, if it's an employee-initiated schedule change and it's documented in writing, you don't have to pay predictability pay. The issue is just if they're staying longer and it's not approved, is that really an employee-initiated schedule change? I would argue that it is, and that predictability pay is not required, but that is one of those gray areas under the ordinance that we're probably going to want to wait for some additional guidance from the city on.
Speaking of gray areas, there was a question that came in about the 15-minute grace period. And does that grace period apply to the start of the shift as well as to the end of the shift?
Yes, Grant, the 15-minute grace period. This question is talking about the employer changing the work schedule and having to pay additional pay if hours are added or subtracted from the schedule. And so that's at the beginning of the shift or the end of the shift or any time. If the change to the schedule is less than 15 minutes, then you don't have to pay that predictability pay.
Another question came in about the access to hours notification. Does that notification need to go to employees only in Seattle or employees, all over the company, whether they're in Atlanta or Baltimore?
Do you want me to take that? Okay. So again, the requirements of the ordinance only apply to, quote, covered employees. And so to be a covered employee, you have to work at a fixed point of sale location in the city of Seattle at least 50% of your time. So if you meet that requirement, then you're going to need to be put on those access to hours lists. If you're not a covered employee and you never work in Seattle, or if you don't work in Seattle at least 50% of the time, then you don't need to be included on those access to hours lists.
Okay. So another question, this relates to the question about mass communication. If an employer only asks one person to volunteer to stay later, they would need to pay extra, is that right? And if that's correct, what if the employer asks two people, would that be considered a mass communication, and would they need to pay?
Yeah, that's a really good question as well, Grant. And this gets to the issue of whether it's a mass communication. And the answer is no. If you are not using that list and sending out a mass communication that meets all the requirements, you would be required to pay that predictability pay.
It needs to be 2 or more employees to be a mass communication. Is that right?
Right. And then this really gets to that group in-person situation that Krista was talking about as well. So keep in mind, those are different situations and they're subject to different requirements.
I think that's going to have to be the last question because we've run out of time. For any questions we didn't have time to answer, or if you have additional questions, please feel free to email Catherine or Krista at the email addresses located on the screen. You'll receive a follow-up email from us today, which will include a certificate of attendance for SHRM or CLE credits. Also, to stay up to date with the latest developments in employment, this ordinance and other areas of employment law, please follow our blogs and sign up for our legal alerts. Catherine, any last comments?
Yeah, and for those of you who do contact us, we'll give you some additional brownie points. We're willing to share our checklist with you that we've created that's a much shorter way to compliance. And if you contact us, we're happy to share that with you as well.
That's great. Thank you so much for participating and attending today. And we will look forward to answering your questions as they come in this new world of the Seattle Secure Scheduling Ordinance. Bye now.